there's a silly question that can I patent my copyright or can I copyright my trademark? These are the sort of questions that we lawyers encounter because the concept of trademark, copyright, and patent is very how do I put it? It's people are confused.
Exactly.
People are confused.
Right. They do not know
they
the
do
difference.
not know the difference. They do
Yes.
not know with of late with there's so many cases happening, so many celebrities who are becoming proactive. People have started recognizing, okay, fine, IP is also a right and you can monetize it.
Yes. How then comes the fundraising part? How seriously do investors look at IP during funding rounds? Starting in today's time, can a weak or unprotected IP actually reduce a startup's valuation?
Yes, it can. It can.
Welcome to Another Dimension by Dipanwita Gupta. I'm your host, and this show is where we try to decode real-world business challenges in marketing, tech adoption that entrepreneurs face while scaling their business in today's fast-changing, tech-driven world. Every episode, we try to bring industry leaders to help business owners understand that what actually drives growth in business, from strategy making to storytelling, from inception to scaling. And our today's guest is someone whose expertise is becoming very crucial, absolutely critical in India's booming startup and AI landscape. We have with us Abhishek Chakraborty, a lawyer specializing in intellectual property rights. He works closely with businesses, creators, and startups to help them protect their brands, innovations, and digital assets, something entrepreneurs often realize too late in their journeys. Abhishek, welcome to the show.
Thank you. Thank you so much.
It's a pleasure to have you on my show. So let's dive straight in. Abhishek, as India sees one of the biggest startup booms ever, what is the single most damaging IP mistake you see early stage founders often make, something that could cause them later in their journey?
See, as you've rightly pointed out, India is the booming startup hub. You may say that third largest in the world.
Right.
It has like 1,57,000 so far, and government recognized startup, and the count is exponentially growing. And so, but there is a slight difference. Last few years, the startups that we have come across, they weren't that technologically driven.
Right.
Nowadays, because with the improvement of internet, with the improvement of technology, we have seen that these startups, they're very heavily technologically driven.
Yes.
So yeah, that is there. But the biggest mistake which they do, which any startup or any business organization for that matter, what they do is, see, there are two things. They don't know. One is identification.
Yeah.
What to protect. And second is when to protect.
Yes.
So what to protect is to identify your intellectual property.
Okay.
Identify your intellectual property. That is, okay. So I start off with a business organization. I'm going to first thing that I'm going to do is I'm going to name that organization.
Yes.
Now that name, whether that name will be with that same name, whether we will be selling our products as well. Now that is something. Then if you are coming up with a different name, then you have two brand names now to deal with. One is your company's name and one is your product
brand name.
With which you are selling your product.
Yes.
So the biggest challenge that comes as an entrepreneur, because they are not from of course they are not, everyone is not from law background, and law is something which is not taught in the school. And so people are not aware what to protect, and then again, as I said, when to protect. So I'm sure that is going to come up in our next question.
Exactly. The next question was like when to protect.
When to protect.
Yeah.
Right.
Yeah.
So my advice would be, so the biggest challenge, mistake what they do is that I think this one picture which I would like to show here, if
definitely we'll show it. Yeah.
In my PPT that I had shared with you, that there's a silly question that can I patent my copyright or can I copyright my trademark? These are the sort of questions that we lawyers encounter because the concept of trademark, copyright, and patent is very, how do I put it? It's people are confused. People are
Exactly.
confused.
Right. Right. They do not know
They
the
do
difference.
not know the difference. They do not
Yes.
know the difference, and it's not that they should know about it,
Mhm.
but people tend to ignore this.
Mhm.
All this while intellectual property right was not something which people had gave importance to. But
Right.
off late with there's so many cases happening, so many
Yeah.
celebrities who are becoming proactive.
Mhm.
People have started recognizing, okay, fine, IP is also a right, and you can monetize it.
Yes.
Okay. So I would say, and as I come back to your question, when to protect. It's like suppose I am saying for the trademark,
Yeah.
or should I tell your viewers that what's the difference between patent, trademark, and copyright?
We'll definitely come to that. Yeah.
We'll come to that. I would say, suppose you're starting your business and you've given a name. I would say go to a lawyer and ask him to generate a search report.
Okay.
Whether there are similar names existing in the platform or not.
Right.
Though that platform is not foolproof, but there is a trademark registry's website which kind of gives you that that search report.
Okay.
And you can and on the basis of which you can kind of strategize whether you can go ahead with that particular trademark that you've thought of, or the name that you've thought for your business.
Okay. Okay. But these things are, I mean, if we decide on a particular name, we often think, okay, we can go ahead with this name. Yeah. And later on we get stuck.
Right.
Yes.
Right. In the process.
Yeah. So many founders spend heavily on marketing even before revenue starts coming in. At what stage should they legally lock down their brand name, logo, and tagline? I mean, it's actually the question.
See, now you tell me something, Dipanwita. You haven't thought about, you haven't given a name to your child, but you're thinking of, okay, fine, which school my child will go to.
Yeah.
It's like you are jumping the gun. I would say your first thing it should be you obtain the statutory right to use the trademark.
Okay.
In your daily course of business. Because once that is sorted,
right,
your business, your marketing, because your entire marketing depends on that. On that brand name.
Exactly.
All your jingles, all your publicity material, all your how do I put it?
Marketing collaterals.
Exactly. Your website, your social media handles, page, domain name.
Right.
Again,
yes.
Another area of topic that we'll talk about today.
Yes.
Everything has that name. Now, if in the very inception you know that, okay, fine, I cannot use that name in future, or there will be some legal repercussions, then why to use it in the first place?
Yeah.
You can, in the very inception stage, you can kind of change the name and take alternative steps to kind of come back.
That's very important.
It's always good to think twice before the arrow is shot, right?
Yeah.
So that's.
I thought of now the next question is something which I could have asked a little later, but let me ask it now. With AI tools now creating ads, brand assets, and content, who actually owns the copyright to AI generated work? The founder, the agency, the platform?
See, in any film business or in any video content creating business, the copyright starts from the person who actually creates or who actually finances.
Right.
A producer.
Yes.
A producer or the media organization who's producing the whole thing. From there, then the director, the script writer. Lot of
there are many entities, many stakeholders.
Yes, that's how the rights flow. But in AI driven this thing, as I said, suppose the example that I gave some time back. Suppose a content creator in his channel comes up with a video of an XYZ celebrity,
right?
And there's something obscene there. I'm sure that content creator's channel will be in the under the scanner.
Yeah.
Even the authorities like YouTube and Facebook will also face some repercussions as to why they couldn't take it down when they saw something like this has been uploaded. So you cannot do away with the liability part. Liability part you cannot shy away with.
That's
something.
True.
That is
Exactly. And now coming to the second stage, a brand name has been decided and the trademark registration has been done. That may take some time, but then comes the fundraising part. How seriously do investors look at IP? during funding rounds, starting in today's time, can a weak or unprotected IP actually reduce a startup's valuation?
Yes, it can. It can, because what happens is, suppose I'll just give you a small example. Nowadays, with restaurants also, the platforms, the third-party platforms, they make it mandatory for you to at least file your trademark application
Okay.
or file a copyright application. They make that mandatory. At least come up with that acknowledgement that you filed it before the appropriate authority, because it gives a credibility.
Yeah.
Of course, it gives okay, fine, your brand is existing,
Yes.
and without registration, you have no statutory protection.
Okay.
You have protection under common law. You can file a civil suit, but I don't know how much of it will be of any help. Without registration, at least in the cases of trademark and patent, registration is absolutely imperative. With copyright, still we can do away with. But then again, I as a lawyer would always say that go and register your copyright work, and of course I'll tell you what actually can come and what actually comes under copyright for a startup. Support.
Yeah, actually, I was trying to chip in between. Before we dive in deeper, can you just in very brief help us understand what should I say, the broader differences between a patent, copyright, and trademark?
So a patent is something that you take for that you get for scientific invention.
Okay.
Scientific invention, and trademark is basically for brand names.
Okay.
Brand names like how do I put it? Like for example, Bata. The entire logo, the way Bata represents their trademark.
Yeah.
That's the entire thing comes under the purview of trademark.
Trademark.
It also has a copyright again. Then again, it comes under copyright as well, because what happens is these brands which has a bit of artistic element in them, so they also come under copyright purview of the Copyright Act as well.
Right.
So, but to register those copyrights, you have to first file for the trademark and get a permission from the trademark registry, and then file again before the copyright registry.
Okay.
But the distinct difference between these three is that patent is for scientific invention,
right.
Copyright is for literary and the artistic work, trademark is again for brand names.
Okay. What should a startup do if they discover midway that another company is already using their similar name after website, logo, and campaigns have gone live?
Right. So again, I'll fall back to my first answer. So it again depends. So it again depends on whether they have taken actual steps to seek proper protection for their intellectual property.
Okay.
Now the strategy will depend on that. Now, if their trademark is registered and in the midway they are finding someone who has copied their trademark,
yes.
They have ample remedies as per the laws of the land. They can take criminal action. They can file civil suits. They can seek for damages. They can, of course, they can also seek for criminal punishment.
Oh, okay.
Yes, and in some cases that criminal punishment can be as you know, criminal proceedings. As facing criminal proceeding itself is a punishment in our country. Supreme Court is n number of Supreme Court judges have said that in their observations that okay, facing criminal justice system in India is itself a punishment. So you can very well imagine a person who's implicated in a criminal proceedings just because he has copied someone else's brand name.
Right.
So yeah. But then again, if you don't have anything, then at times you can kind of carve your way out and kind of mutually exist.
Okay.
But then again, you one day or the other you'll have to rebrand yourself. Right. And no company or no organization at any stage would like to again rebrand themselves, because you build a brand. Because you build a brand in order to establish some amount of goodwill. Absolutely. and so that people fall back to that brand whenever they need to purchase a particular product.
Yes, that creates a brand recall.
Brand recall, right? So, but that won't happen. Because and people will be like, and people are apprehensive of rebranding their business at when they are 5 years or 10 years down the line. Right. So I would say it's better to first the moment you think of a logo or the moment you think of any jingle or any publicity, this thing, have it run through your lawyers, get it checked, whether you are compliant with all the IP this thing, all the IPR IPR rules and laws, or any other prevalent laws of the country.
All right.
Right.
Okay.
Because as I said, there are a lot of aspects. It's not just IP. When you're doing your business, now when I would just like to recall something from my college days. Okay, so there was a subject called Law, Business and Society. So we were the first MBA batch of Nalsar,
okay,
which incorporated law and management together. And we had a subject, Law, Business and Society. And in the first class, my principal was taking along with our professor, Mr. Siddharth Chauhan, and we had a very unique way of doing this particular class, because the class was divided into two. We had the topic was given and we had to argue and debate like a parliamentary debate. So that's how we used to learn. But this opening class was started by our principal, and he said that, okay, fine, why law and business together? He said, in any country, your business might be really good, your business idea might be really good.
Yeah.
But if it is not legally viable, it has no value, because one day or the other you'll have to shut it down. Right. Otherwise, smuggling would have been a legal profession by now, legal business by now. But then no, it isn't. You cannot survive long you will come behind bars if you are engaging in a business like smuggling or money laundering, of course.
Yes,
right?
yes,
so, yeah.
yes. Okay. A lot of founders assume that owning the domain name gives them rights over the brand name. Is that true? Or
absolutely not. It's a misconception. Absolutely not. On the contrary, owning the trademark registration gives better protection to your domain name, because your domain name is not or in most of the cases that we come across, the domain name is the name of the brand or name of the company. So if your company's name being a brand name is not protected, then how is your domain name protected?
Understood.
It cannot have that protection.
Right.
So you have to have registered both. You have to have both the things registered, and then carry on. Of course, yes.
The roadmap ahead. If a small business that has a limited budget, what should they protect first? The brand name, product design, the technology, or the entire content?
I would say technology and the brand name.
All right.
Patents. Technology will involve patent, and brand name would involve trademark. So these are the two things I would suggest, that go ahead and protect them first, because these are easier to infringe. And these are the two most required thing in whatever you're dealing with in the due course of your business.
Great. So we are at the fag end of this conversation, and one message you would like to give to our viewers, the wannabe entrepreneurs, the startup entrepreneurs, about protecting their IP.
I would say, as I said in the very beginning, that moment you decide on your moment you decide your technology, or moment you decide which business model or technology idea, the brand name, at the very inception, go to a lawyer, seek their legal advice, and identify.
Most of the time, they go to the lawyer.
After the arrow has been shot. But I would say, go to a lawyer, go to a person who's knowledgeable about IP laws, and who would be able to guide you as to, at least, if not guide you, at least help you identify that what is your IP and what are the IPs that you go and you must protect at this stage.
Right. Okay. So before we wind up this session, I'll like to ask you a few quick questions in the rapid fire round. One IP mistake you see every founder make?
Not generating a search report and deciding on the trademark or the brand name without consulting. All
right. This you have already answered, but once again, trademark first or domain first? What's your pick?
Trademark first, patent if your product is very much technologically driven, and if your technology is novel, then patent, of course, and then trademark, as I said.
Okay, what lies ahead? I mean, in 2026, what will be your advice for founders? Like, as you said, I mean, go to your lawyer and learn about IP. I
Of
mean,
course. No,
identify.
not just go to your lawyer. See,
Mhm.
at this stage, at this in the world of technology, in the world of internet, you don't need to go to your lawyer all the time. But in order to have a basic idea of what IP is, you can there are plethora of materials over the internet
Yes,
and all that.
yes, yes.
But again, a person whose profession is practicing, who's a practicing IP lawyer, he'll be able to guide you as to, because he's professionally experienced. Hence you go to your lawyer. But knowing about IP, you can of course there's no limit to learn. You can learn
Right,
any
right.
you can learn any given day. You can start that learning any time. Like I'm sure most of the entrepreneurs, they're well versed with income tax. You'll ask them how किस पे tax लगेगा, किस पे tax नहीं. They're very well versed. Like same way, this knowing or being IP awareness is very important.
Yes.
IP
right.
awareness is very important, and surprisingly, Calcutta once upon a time was the IPR hub. And just to give a small trivia to the audiences, that first IPR law firm was started in Calcutta.
Okay.
So you can very well imagine the legacy that IPR, the legacy that this place has, and there are good professionals. I would say there are good professionals. You always you just need to reach out to them.
Okay. Okay, and the last question, this is not related to IPR. If not an IP lawyer, what would you have been? What career would you have chosen, if not law?
I think I would have been an actor, producer, actor.
Okay, you have been associated with
Yeah,
theatre
I have done theatre for quite some time.
Mhm.
I was associated with a group called Theatrician, whose founder is a lawyer, by the way.
Okay.
Tathavata Chaudhary, he's a lawyer himself. So yeah, I think I would have become a producer. I would have been a producer.
That's
I would have
awesome.
produced movies, because that's what got me into IP law. Because that's what got me into IP law, because that's one one aspect of law which connected movies with law.
Okay, that's interesting.
Because copyright law is all about film, and it is more it's something which is it's more applicable to the people from belonging to the film industry.
Right.
So they are the ones who tend to protect, because it is all about artistic work, protecting your artistic work. Okay. Copyright is all about that.
Yes.
So these are the people who go for such registrations and all. So that's there. So
thank you, Abhishek, for this insightful conversation. We really got to learn a lot of things. I mean, and I'm sure my viewers who have watched this episode got a few important takeaways. And just go back to your dashboard, go back to your office, sit with your lawyer, and if you're still not registered your trademark or patent or copyrights, go and do that before it's too late. So, and if you liked this episode, don't forget to like and subscribe to our channel. Till the next episode, bye bye, have a great day. Thank you.